High Court Advocate George Kithi says that there are statutory laws that the engineers, architects and landlords have to stick to in the whole process of putting up rental buildings. However, he says due to Kenyans' peculiar habits of taking shortcuts to beat deadlines and make quick cash, that has resulted in flouting of these laws.
The instances when building collapse without necessarily the negligence fault of these people. For instance, if there's an earthquake or flood, then that's a reason to probably can be said to be an act of God and therefore excusable. But if there's outright negligence of all these players are involved, for instance, if the building is constructed such that it cannot withstand what otherwise would have been foreseeable danger, then they become negligent and therefore liable.
The Survey Act of 1989, the Water Quality Regulations published in 2006, and Water Resources Management Rules of 2007 define riparian land as being a minimum of 6 meters up to a maximum of 30 meters on either side of banks from the highest water mark. However, according to Advocate Dunstan Omari, developers have defied this and developed houses on riverbanks, and this has contributed to the collapsing of buildings, especially in urban areas.
What we have in this country, when there was a lot of grabbing, very many people have built within a riparian area. The fact that the river does not appear to be strong this time does not mean that that passage of the river will never one day have torrential rains and cause problems. For an example is the UK and the Westgate supermarkets in Nakumatt around Westlands. That area was a swamp area.
The law protects tenants, especially low-income earners. This notwithstanding, their rights are poorly respected, especially in the informal settlements, where housing and environmental standards are extremely poor.
If one has built in an area that he is not supposed to build by law, therefore the building that is there will be demolished and the landlord will pay the costs of demolishing that building. If there were losses incurred in terms of life, if there were losses incurred in terms of destruction of property, if there were losses incurred in terms of special damages, in terms of anguish and victim impact, the landlord will be held responsible.
But this is not blanket protection. Tenants too are required to demand for the verification certificate of compliance from the landlord before occupying the house. Halligan Agade, Business Insight.